Is everybody good? Oh, all right. Good. We're live. Okay, this is a call to order for the November 20th, 2025 meeting of the Santa Clara County Planning Commission. Will the clerk please call the roll?
Good evening. Commissioner Hetterly is absent this evening. Commissioner Cohen.
Present.
Commissioner Belska.
Present.
Commissioner Levy. Present. Commissioner Escobar.
Here.
Vice Chairperson O'Donohue.
Here.
Chairperson Rouser.
Present.
You have a quorum.
And we each have our own microphone today. This is exciting. Please stand if you're able to join us in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Good evening. My name is Mark Rouser, and I'm the chair of the Planning Commission. On behalf of the Commission, welcome to today's meeting. At this time, please turn off or mute all electronic devices, including cell phones that may interrupt the meeting. The first item on the agenda is public comment. This item is reserved for persons who wish to address the Commission on any matter within the subject matter jurisdiction of the Commission that is not on this agenda. The law does not permit Commission action or extended discussion of any item not on the agenda except under special circumstances. Members of the public who wish to address the Commission on a non-agendized item should request to speak at this time by giving a request to speak form to the Deputy Clerk if you're in the chambers, or by using the raise hand icon if attending virtually. Do we have any speakers for item 3?
One moment for the Zoom room, and we have no speakers this evening.
All right, item number 4 is consent calendar. Approve the consent calendar and changes to the Commission agenda. Has everyone had a chance to look at the 3 agendas in the consent calendar?
You mean minutes?
Minutes.
Just
That too.
checking.
That too.
That would be a yes then.
Would anyone like to make a motion, or is there any discussion on
I will motion that we approve the minutes as written.
consent
Second.
calendar?
Yes.
Okay, we have a motion by Commissioner Escobar and a second by Vice Chair O'Donohue. Any other discussion? All right, let's take a roll call vote.
Commissioner Cohen.
Yes.
Commissioner Belska.
Yes.
Commissioner Levy. Please use your microphone. There's a gray button.
If it's not working, you hit the one right there? No. Press that little button. It should light up. It's not
I
lighting up when you
will.
press
Somebody's
the
going to come out and help you with that. Commissioner Escobar.
button. Yes.
Vice Chairperson O'Donohue.
Yes.
Chairperson Rouser.
I approve.
Motion carries.
Okay, item 5, public hearing to consider an appeal of the June 9th, 2025 decision by the Department of Planning and Development to deny a grading abatement approval. The specific appeal ground is that the grading is necessary to expand an existing adjacent nursery wholesale use onto the subject property. California Environmental Quality Act, CEQA, not applicable pursuant to Public Resources Code Section 21080B5 and Section 15270 of the CEQA guidelines. The appellant applicant is MH Engineering Company. The owner is Coyote Valley Nursery Incorporated. The property address location is 355 Kirby Avenue, Morgan Hill. Assessor's parcel number 725-02-028. Zoning is A-40AC-CV. Supervisorial District 1, file PLN 24-044-APL1, ID number 126808. We have possible actions of denying the appeal and upholding the decision of the Department of Planning and Development to deny the grading abatement approval, or declare intent to grant the appeal and rescind the decision of the Department of Planning and Development to deny the grading abatement approval and return to the Planning Commission for final action. So if we could begin with a staff report on that, that'd be great.
Thank you, Chair Rouser and members of the Planning Commission. Lisa McKyle, Deputy Director. We have with us tonight Michael Shui, Associate Planner, who will deliver the presentation. He's accompanied by County Counsel Christina Stella and Principal Planner Rob Salisbury. And this is an appeal in the Coyote Valley area of the county. Thank you.
All right, good evening, Commissioners. My name is Michael Shui, Associate Planner with the Department of Planning and Development. This evening, I'll be presenting item number 5, an appeal of the June 9th, 2025 decision of the Department of Planning and Development to deny a grading abatement application. This project is located in unincorporated Morgan Hill in Coyote Valley, carries a general plan designation of agriculture large scale and a zone exclusive agriculture with a 40-acre lot size combining district and Coyote Valley Climate Resilience Combining District. Surrounding uses consist of agricultural uses and low-density residential. The area to the southwest is the existing nursery operation, and the area to the northeast is the subject property on which the base rock was spread. This item is an appeal of, sorry about that. This item is an appeal of the June 9th, 2025 decision of the department to deny the original application to legalize unpermitted import of base rock on a property. On May 15, 2019, the previous property owner was issued a notice of violation for non-exempt grading without permits, grading, creating a nuisance, among other uses. The violation was based on an investigation in April 2019 that found compacted base rock imported onto the site for roads and partition lots had been spread over approximately 7 acres of the subject property to a depth of 4 inches, totaling approximately 3,699 cubic yards. In September 2020, the court issued an order directing the previous property owner to abate the violations described within the notice of violation, including the non-exempt unpermitted grading. In March 2021, the subject property was sold to the current property owner, the longtime operator of Coyote Valley Nursery, which is located on an adjacent parcel. While the current owner has indicated that he would like to expand his nursery operations onto the subject parcel, and this use is allowed by right, he is still required to obtain permits to construct improvements and has not applied for any permits or submitted any plans for this expansion. In August 2023, the property owner entered into a compliance agreement agreeing to a timeline to abate the violations, including by obtaining grading permits to legalize the non-exempt unpermitted grading. In March 2024, the property owner provided their first grading abatement application submittal to legalize the non-exempt unpermitted grading of imported base rock. The application was deemed incomplete on 3 occasions and was ultimately deemed complete on April 10, 2025, although zoning compliance issues were outstanding. On June 9, 2025, staff denied the grading abatement application due to inability to make the required findings. The applicant appealed the department's decision on June 24, 2025. The department has determined that the compacted base rock spread throughout the property meets the current zoning ordinance definition of development area, which is defined as that portion of a property within which buildings, accessory structures, and associated improvements are proposed and delineated on site plans or subdivision maps in accordance with applicable policies of the general plan or the zoning ordinance. Associated improvements include, but are not limited to, driveways, parking areas, turnarounds, septic systems, patios, pools, and recreational facilities. In 2019, Coyote Valley was designated as an area of statewide significance under Assembly Bill 948, which established the Coyote Valley Conservation Program. The zoning ordinance specifies that within the Coyote Valley Climate Resilience Combining District, development area is limited to 2 acres maximum with on-site agriculture and 1 acre maximum without. The purpose of the CV Coyote Valley Climate Resilience Combining District is to effectuate direction from the state to protect this irreplaceable agricultural greenbelt area as a means of increasing regional climate resilience. The predominantly agricultural lands of Coyote Valley are unique in their combination of natural characteristics, which are well suited to providing ecological and public benefits, including flood attenuation as a result of sustaining wetland health, maintaining water supply as a result of protecting groundwater recharge potential, and carbon sequestration made available from natural and working lands. In the department's view, the unpermitted grading does not meet the agriculture grading exemption, and the property owner agreed through the compliance agreement that the grading on the property was expressly not exempt from the grading permit requirements. The total area covered by the imported base rock is approximately 9 acres, well in excess of this 2-acre limit. In addition to the proposed grading in excess of the 2-acre development area limit, certain required grading findings listed in section C-12-433 of the County Ordinance Code cannot be met. Specifically, staff found that findings B and E can be made, that finding G is not applicable, and findings A, C, D, and F cannot be made. Finding A of C-12-433 requires that the amount, design, location, and nature of any proposed grading be necessary to establish or maintain a use permitted by the zoning ordinance on the property. The water property owner has stated that they intend to expand a nursery onto the subject parcel and that use is permitted by right. They have not submitted any detailed plan or proposal to demonstrate how the current amount of base rock is necessary to establish that use, and therefore the department cannot find that the proposed grading is necessary to establish or maintain a use presently permitted by law on the property. Finding C of C-12-433 requires that the proposed grading minimize impacts to the natural landscape, scenic resources, and minimize erosion impacts. As explained in the staff report, the department has concluded that the applicant's proposal does not minimize impacts to natural landscape. Finding D of C-12-433 requires that for grading associated with a new building or development site, the subject site shall be one that minimizes grading in comparison with other available development sites. The unpermitted deposition of more than 9 acres of base rock, even if related to an agricultural use, is not exempt from the development constraints and regulations applicable in the CV combining district. The original unpermitted grading was not for agricultural use, and the applicant has not submitted information to demonstrate that the current amount of base rock minimizes grading compared to other sites. Finding F of C-12-433 requires that all proposed grading conform with any applicable county general plan policies. The proposal to legalize non-exempt, unpermitted grading of over 9 acres of crushed base rock reduces the potential to use the property for soil-dependent agriculture, thereby conflicting with multiple general plan policies. Regarding CEQA for the project, per section 15270 of the CEQA guidelines, CEQA does not apply to projects which a public agency rejects or disapproves. As the department denied the grading abatement application, the county did not conduct CEQA analysis for this project. Staff recommends that the commission deny the appeal and uphold the decision of the Department of Planning and Development to deny the grading abatement application. Should the Planning Commission overturn the department's decision, CEQA analysis would be required, especially to consider the environmental impacts of this project on the resources of Coyote Valley. This concludes staff's presentation, and we're available for any questions. Thank you.
All right, we'll open it up to the commissioners. Do you have any questions for staff on the presentation? I'm not seeing any. We'll go ahead and open up the public comment portion, and the applicant will receive 10 minutes for the initial, and then we'll open up the rest of the public, and then 10 minutes for rebuttal at the end.
To the chair, I have speaker cards for the following: Gloria Ballard, Dylan Yamasaki, Mario Silva, Christian Silva, and Bart Heckman.
Chairperson Rouser, there, we got it, Chairperson Rouser and Planning Commissioners. MH Engineering is representing Mr. Silva. Dylan Yamasaki is here, and he's the engineer that created the grading plan. Mario Silva's here, and his son is also here. And Bart Heckman will wrap it up for us. MH Engineering prepared a grading plan to resolve a grading violation. We are going to make one minor correction. The staff report quantities are different from what we finally ended up with. The quantities were much larger that we wanted to keep on the site. When the project started, staff objected to it, and we've made that quantity smaller and smaller. I have a packet that I'd like to give to the planning commissioners. The first page is just an article of how important nurseries are to Santa Clara County, and the packet underneath are photos that we're going to show you and explain to you what they are for the commissioners that weren't able to come out to the site. Could you give each one? And there's one in there for you, Peggy. Okay. We hope to present sufficient evidence to allow you to make the findings for items A, C, D, and F. Mr. Heckman, so we don't reiterate each other's presentation, will address the findings at the end of this meeting. Our biggest obstacle is the interpretation that the nursery uses development. We hope the photos will show you that it is truly agricultural. I would like to make another item clear. Staff's report said that no permits had been issued. A wholesale nursery is a matter of right. It doesn't require any permits unless we go to do a building. No buildings are proposed. They have shade tents that they put over some of the crops to keep the sun from burning them. Much of the other crops are on base rock, on mats, on the land. So the only permit that would be needed for this wholesale nursery would be a grading permit. This application that we have filed is a grading permit. It's called an abatement permit, and we're proposing that what grading remain on the parcel is called out in the engineering of this plan. So we did want to make that clarification. And I'll introduce you to Dylan Yamasaki, and he's going to go over the photos that we took for those commissioners that have not been able to see the site. Dylan?
Good evening, Planning Commissioners. Dylan Yamasaki with MH Engineering. Peggy, if you could you cycle through these pictures relatively quickly? This first one is an aerial photo of what the site currently looks like. It differs from pages 20 and 21 of your packets showing the unpermitted items on there. Next one, please.
She's calling up the second photo. One moment.
Oh, sorry.
There were 3 different PDFs, and she'll cycle through them.
Can we just pause the timer while we're trying to get these things up, just so we don't put pressure on everyone? Thanks.
So these are pictures of the Coyote Valley Nursery as it is today. We went out on site a few times. This is the nursery crops looking to the northeast, and if you scroll down, this is looking towards the non-violation area that's covered with a shade structure right now. Go ahead and keep cycling through there. This is looking to the west towards the Coyote Valley Nursery operation that's going on right now in the adjacent parcel. Below are just the current use of how they're utilizing the base rock. These are some more pictures here, all from different angles, looking west, and this one's looking to the north. Okay, figure 8, this is some more pictures of the nursery, and figure 9 is the area that's being utilized in the non-violation area on top of wooden nursery benches. This is not the preferred way that the Silvas would like to grow their nursery crops. Could you continue on to the next PDF, please? Okay. The following pictures, these are all nurseries in Santa Clara County. These pictures will provide examples of different nurseries in the areas. There's 15 nurseries here. All of them have base rock on the ground that they're utilizing for their agricultural use. That one's north of Gilroy. This one here, JC Nursery, Menlo Growers. Go ahead and keep going. Lakeside Nursery, Greenfield Nursery on the east side of 101. Moon Valley Nursery, this is one that you drive past just north of St. Louis Regional Hospital. And these are some other nurseries.
Did you make the correction on that quantity?
Oh, yes, in the packet, it shows the initial application had a incorrect quantity of proposed base rock to stay and some to be removed. The correction would be that we are proposing to remove 1,592 yards of base rock and 2,221 are to remain. Thank you.
Through the chair, could I just ask, can we pause? Can I get those numbers one more time? Just for the record.
1,592, 2,221.
That's correct.
Thank you.
So I am Mario Silva, and I want to say a few things about the nursery. I've been farming since 1980. I worked for the company for 26 years. And always, it's been, the gravel is always in the place. And the nursery business has been like that for a long, long time. Since 2006, when I started in Morgan Hill, it was already the gravel there. So since I remember, I mean, all the time it's been no issue with that. But now it's been a problem. But the reason I use in the gravel is because the plant material I use, I don't put it in the ground. I put it in pots and liners. It takes a long time. 8 weeks, 10 weeks. And we have to water around. We have to be with the hose, I mean, by hand, and driving the cars around. And the golf cars, I mean, to pick up the plants is another issue. It's a good example today. It's raining, a raining day. It's really wet out there, muddy, and where there's no gravel. But that's the only reason I've been saying, and I've been proposing to me to keep the gravel, because I really need that to continue growing my material. And that's been, like I said, it's been a long time being farming, and that's the first time I have in the situation like that. So unfortunately, but that's all I want to say. I mean, I'm not a person to talk up, too much, so because I don't know much about it, but I just want to say that. I not come out with something just out of my hands or out of my pocket or anything like that, because I've been farming for a long time. So I appreciate, the time you give us, the time that you give me to me today. So thank you.
Thank you.
I'll be quick. Bart Heckman, Land Use Council for the nursery. 3 quick responses to staff. The only permit needed to do what they want to do is a grading permit, which we can't get until we get the grading abatement approval, which is why we're here tonight. In slide 4, you saw a statement, compacted base rock counts as development area. That's really the crux of the issue tonight. That statement is not from any ordinance of the county, nor is it from your general plan. That is a staff opinion that staff believes should be true, and in your draft ordinance, they've included that. And so if that draft ordinance is ever approved in that form, which is doubtful after Tuesday, that'll be true. But today it's not. The base rock is not stated in your code as development area. And here, for the reasons explained in my letter, which I hope you've all read, it is just a platform for the undeniably agricultural nursery, commercial nursery use. I have in my letter addressed the findings and explained why they can all be met, and if any of you care to ask me to elaborate on that, then I can do that, but I'm out of time. Thank you.
Any questions for the applicant? Vice Chair O'Donoghue?
What kind of vehicles do you drive for your nursery, and tractors? What kind of heavy equipment do you have to use to move plants and trees around?
I got golf carts and a forklift and a tractor, and the trucks that carrying the plants. I mean, deliver the plants. I deliver the plants in the big trucks.
And when you're driving those vehicles on base rock versus non-base rock, what happens to the forklift when?
Yeah, I can get in. I can get in. Like I said, for example, today is a good day. I mean, I can get in where there's no gravel. The golf cars can get in. Forklift can get in. The tractor, yeah, the tractor I can get in. But the main thing is the golf cars, we have to go around to pick up the plants and put them in the truck to deliver. So that's the only way we can get it. And the other thing is, like I said, we have to water every day by hand. And we are in the water all the time, I mean, around the plants. So that's the only reason.
So on a day like today, when we've got about a ½ inch of rain, you can't really do your job if you're not having base rock to drive around on.
That's correct.
Okay, thank you.
Thank you.
Sorry, if I could just interrupt. Could I give a reminder for everyone to disclose all their ex parte?
I was
Okay.
going to get to that.
Usually happens at the beginning, so I was worried we had forgotten.
Yeah,
But
no.
go ahead.
I had ex parte communications with the applicant about their appeal.
Thank you. And just a reminder that we should not just state, I spoke with the applicant, but you should also briefly summarize the contents of any communications and any factual information or evidence shared with you. And if you went on a site visit, you should also disclose that and state any observations that are relevant to your decision on the matter.
Do you want me to go into detail, or was that enough?
Please do.
Okay. I spoke with Gloria Ballard about their appeal and listened to her concerns. I did not go on site.
Does anyone else want to, why don't we just disclose everything right now, and then we'll continue on with questions?
Yes,
Commissioner Belska.
I had a site visit where I received a tour of the site and was told, basically we discussed how a wholesale nursery operates. So it was predominantly conversation about their business and how they operate, like the trucks and those types of things. And then I also received a packet of information. That packet was submitted to Peggy, and it was posted prior to the meeting. And I believe some of the materials we received today were part of that packet as well.
Okay, and I also, a couple of months ago, had a site visit and was able to drive a golf cart around the facility. And did notice they had the shade structure up, a lot of plants in there, a lot of workers attending to the stuff. And I'm not sure if I might have been given material, but it was the same thing that was presented for Commissioner Belska, the same information. I also, as my first job, paid, was at a nursery where I had to water over the summers. And I can attest that the water, it is good to have base rock when you're watering these things, because it just gets muddy everywhere. So that was in Cupertino back in the day. Okay, any other questions for the applicant? I'm not seeing any.
Chair Rouser,
Yeah,
I would actually be interested in hearing how the applicant considers each of the conditions and how they're making those findings. Or we can do that after staff, after we ask staff to do the same thing. But yeah, I think, the whole crux to this is seeing whether they make the findings or not. And staff outlines that there's, the 4 areas, I think it is, that they don't make the findings. And I wouldn't mind hearing how the applicant counters that.
oh, okay, let's entertain that. Bart, you want to walk us through basically your memo?
Yes.
Absolutely, absolutely, and thank you for the opportunity, Commissioners. So 4 findings are agreed to, 4 are in dispute, if you will. I don't know, I thought there was maybe a slide that you had with the 4 in dispute, and that might be helpful to pull up so that you can put eyes on it.
Through the chair, we have an exhibit with the findings. You want us to pull that
The
up?
table?
Yeah,
The table, if you got that.
That's a multi-page, I think that's a multi-page document. So yeah, you can flip through it if you want. That'll work.
One moment while we pull that up on the clerk's side.
And for the commission, I believe it was attachment D,
D.
as in David.
It was a supplemental.
I believe that's the correct item, if it's possible to make it full screen. I think, yeah, that's fine if you can just blow it up a little bit.
In the bottom right, there's a zoom in, and that works too.
Yeah, there you go.
And through the chair, we may want to, we may want to scroll up to start with the
Yeah.
first page. There we go. Okay.
Yeah. So I hope the commissioner's eyes are better than mine, because I can't see it. That's a little bit better. Right, and so this is what you're looking at now, attachment D, it's part of your supplementals, is actually a combination of all the findings, those that the staff agrees can be made and those that staff felt couldn't be made. And so I'm obviously in agreement as to ones that staff thinks can be made. We're going to focus on the 4 they say can't. And so the first of those is at the top of the page there. It's finding A, which is the amount, design, location, and nature of any proposed grading is necessary to establish or maintain a use presently permitted by law on the property. So the first thing we have to do really is look at that word necessary. And as I point out, you have to read all of this county's laws have to be read together and harmonized. So when you look at your general plan policy RGD22, which is one of your grading policies, that talks about necessary grading in terms of being reasonably necessary. And that's important here, because if something's strictly necessary, that means if you're not allowed to do the grading, there's no way to do it. But if it's reasonably necessary, then you're looking at sort of what's a reasonable, is it reasonable to use, in this case, base rock this way? And I think we've demonstrated not only that this is it's agreed that this is the nursery use is a use presently permitted by law, by your zoning on the property. And as we've shown for this operation, like all the other operations shown in the photographs that I provided and the additional ones that have been provided, many commercial wholesale nurseries use this. And to us, that demonstrates that it is reasonably necessary in the operation of a commercial nursery. Again, it's not that that no nursery could operate without base rock, but it's that many do because they find, for all the reasons I state earlier in my letter, that it's a more cost-efficient, cleaner operation that has many benefits. So that's why we think finding A can be made. Finding C is the next one in dispute. And there it is at the top of the page. So most of this either doesn't apply, well, most of it doesn't apply. Okay, grading will minimize impacts to the natural landscape. Let's start there for a minute. There is no natural landscape on this property, right? There's no part of this property that is in a native condition. This has been this was for decades farmland and treated that way, and crops grown on it. The prior owner had this different and illegal vision. But there is no natural landscape to be disturbed on this property. There's no scenic issues or aquatic issues on this property, and the only potentially biological issue is this notion that base rock is harming the soil. And there's no report or evidence of that provided in the staff report or anywhere to my knowledge. Remember, this base rock isn't permanent. It's laid on the ground, and at such time in the future as a different use, maybe orchard or row crops want to be planted, it can be removed to expose the soil, which has in some ways been protected from erosion by the base rock. And that is really the end of finding C, is minimize erosion impacts. This is a beneficial activity to prevent erosion of this soil until such time in the future as it will be exposed and used. So that's why we believe C can be made. Moving to D, so D doesn't really apply here. Staff has tried to apply it. And what it says is, if you're doing a new building or development, is the grading in one place less than the grading in another place? And I have worked on many county projects that use this, and here's an example that it most often comes up with. Somebody's got 10 acres and they want to build a house. They can do it over here, and there's a certain amount of grading, or they can do it over there, and there's a different amount of grading. And what this finding does is lead them to the place where there's less grading needed. It's that simple. That doesn't apply here where we've got a large farm and all of it's going to be used for farm. There is no alternate place on the property to farm because it's all going to be used as farm, which is why I say it's not really doesn't apply here. But to apply it, there is no other available development site on this property where we could do this because we're doing it throughout the property. And then finally, the last one that's in dispute is finding F, which is on the next page at the top there, and that is the grading conforms with any applicable general plan or specific plan policies. So this is the one that really gets to this issue of development area versus agriculture. And staff in each of the, I think, 8 general plan policies really addressed the policy from the lens that this is development, not agriculture. And for the reasons we've stated, that those photographs, this is indisputably agriculture. It's not development. It is base rock to support an agricultural use of the property. And when you view it through that lens, for each of those 8 policies, we fit. We are not inconsistent with any of those. And I point out that in addition to the 8 that staff identified, there's another one they didn't point out that our use is consistent with, and that is General Plan Policy RGD 23, which talks about exporting material from a site, and it suggests that you shouldn't do it if that is going to require a lot of hauling over a lot of distance, because that creates emissions and traffic issues. And so by retaining as much base rock on the site as we're trying to, we are also consistent with that policy that wasn't raised. So those are the 4 findings that are in dispute, and why we believe that all of them are met when your code is appropriately and properly applied to recognize this use as agricultural. Thank you for the question.
Thank you.
Okay, any other questions? Commissioner Belska?
I have questions for staff, not the applicant. Is now the appropriate time?
Well, let's go through the public hearing just to see if there's any other people that want to speak on this subject.
We have no speakers in chambers, and 1 minute for the Zoom room. We have no remote speakers.
Okay, well, I'll close the public hearing.
One moment. No.
Do
From a
we,
process standpoint, I think you want to leave the public hearing open until
okay.
you offer rebuttal to,
okay, so we'll have questions from staff, and then if, we'll give the applicant a chance to rebut or clarify anything that, or we may have further questions for them. Commissioner Belska.
Yes, thank you. So questions to staff to clarify some things. So is a wholesale nursery that cultivates plants considered agricultural use?
That's a very good question. If you look at the parenthetical definition of the zoning ordinance, that's appended to each use classification. A commercial, a nursery, whether wholesale or resale or retail, is a commercial use, not an agricultural use.
Is the cultivation of plants an agricultural use?
Hi, Deputy County Counsel Christina Stella. So our zoning ordinance is very clear in section 2.10.040 that nurseries are commercial uses. They are not considered agricultural uses. The fact that nurseries are allowed by right in ag zones is different from them being classified as agriculture.
Would you mind bringing up because I haven't seen that part. I was just looking at the definitions for agriculture, and that seems to imply that cultivating crops, including in greenhouses, is defined as agriculture. Could you bring up what you're referring to, where they are specifically defined as commercial?
Yes. Well, I can't, but I'm sure someone can.
We're going to give permission to staff through the chair, and then either Rob or Michael can share.
Mr. Shui is connected to the Zoom meeting, so we'll let him bring it up here.
So while he's bringing that up, I do want another clarifying question. So staff is saying that they can't make the findings because the applicant hasn't submitted any permit applications, but it sounds like that they either can't or there is nothing for them to submit to. If they're not proposing any building, then there's no reason for them to be submitting for a building permit. And the applicant stated that they can't submit a grading permit until the grading violation is is cleared. So, so what could they possibly be submitting then?
First of all, I think they could, in my opinion, submit a clearer plan that clearly delineates how the various sections of base rock are proposed to be used. Secondly, I would say, in my opinion, the more fundamental question is whether the deposition of base rock truly should count as development area or not. And in our zoning ordinance, development area the definition doesn't include what surfacing or what materials those areas are made of. It really speaks to the use of areas. So if you look at the definition of development area, it doesn't say asphalt or cement is development area. It speaks to improvements, it speaks to driveways, access ways, things of that nature. I think we would all agree that pavement or cement likely would be considered development area. And I think similarly, base rock that's deposited for whatever purpose for a commercial area in order to facilitate a commercial use, arguably does constitute development area. And the Coyote Valley Overlay District is very clear in the limitations that are of development area that is allowed.
I can also help clarify, Deputy County Counsel Christina Stella, that by right uses don't require a permit to establish the use, but they do have to apply for other types of permits, including grading permits. So this grading abatement approval is a precursor step to obtaining a grading permit. But just because an operation is allowed by right doesn't mean that it doesn't have to apply for and get approval for all other types of permits.
And
Go on.
The screen is now showing the zoning ordinance definition of nursery with the parenthetical categorization of the use as a commercial use, not an agricultural use. Hopefully that's visible to you on your screens there. This is page 39 of the zoning ordinance, and this is the use classification section.
Sorry, can you scroll up so I can see the context of what section we're looking at here?
This is section 2.10.040, which sets out non-residential use classifications. And so these classifications are codified in our ordinance, and we are bound to follow and apply and enforce those categorizations.
Through the chair, you also notice, I believe Commissioner Belska asked about cultivation, and it does notate cultivation.
Mr.
Okay,
Shui, do you
thank
want
you.
to scroll up to the very beginning of this section where it talks about the purpose of those parenthetical notations? This is page 29, bottom of page 29.
Okay, I'm going to ponder that for a bit. Thank you.
Can you just scroll down? What was mushroom again on that one? Okay. Do you have any more questions for staff right now? I'll go to someone else if you're, okay. Vice Chair O'Donoghue.
Yeah, this is a question for staff. I'm looking at the zoning ordinance, and for wholesale nurseries, A zoning, AR zoning, and HS zoning all have for wholesale nurseries by right. How do you determine that versus a use permit?
As to how these were originally determined as to what was an appropriate use by right, what required a use permit, these definitions were established far before my time. But I think, generally the idea is that uses allowed by right are low intensity and small scale enough to not require permitting or review or a complex or intensive review and approval process for establishment of the use.
Understood on when they were established. They've been that way for a while. But if wholesale nurseries by right are allowable in the agricultural designation, the agricultural ranch land designation, and the hillside HS designation, I think you have a strong argument for wholesale nurseries having an ag component. So I just wanted to make that point.
If I could clarify, so again, the classification of the use is different from the permitting required for that use. And even businesses or uses that are allowed by right are required to obtain other permits. So for example, even if a use is permitted by right and no permit is required to establish that use, it still cannot be graded in a way that doesn't meet our grading permit standards.
And similarly, could not exceed a development area limitation as prescribed by the Coyote Valley Combining District.
If I may, Jacqueline Anciano, Director of Planning and Development. When someone has a house that's allowed by right, you still have to get the proper permits for the foundation, for the construction of the house, for the, if it needs a septic system, they have to go to the health department. So just because that house is allowed by right, doesn't mean that they just build it.
Yeah, I would definitely agree with you, and it sounds like that's, this is the crux of the issue, and they do want to get a permit.
Through the chair, if I could take a stab at, I believe, Commissioner O'Donoghue's question about how one determines use permit versus by right. As Mr. Salisbury said, it's often based on the intensity of the operation. And so typically with a retail environment, you're going to have a lot more coming and going and more traffic. Wholesale, you'll have less of that. You'll have somebody coming to pick up several plants and leaving for a construction property. And so it's larger scale, if that helps.
Thank you.
Can I ask the Coyote Valley Climate Resilience Combining District, that was approved in December of 2021. When did that actually go into effect? Was that immediately upon approval, or was there a designated date that it became active?
So first of all, the state designated Coyote Valley of an area of statewide importance. The county also responded to that. It has to go through a process when we're amending our code. I'd have to look up exactly when it went into effect, but you typically have to go through the process, Planning Commission, the board, and there might be one or two readings. So let me see if we can look into that.
The board approved it on 12/14/2021.
Yeah, when did it go effective?
But sometimes they say this is, effective next year or upon signing.
Yeah, it depends on the ordinance too, what it says in the ordinance, so we might need to look.
Okay.
My understanding is that the default is 30 days after adoption, the second reading, it becomes, or after adoption, it becomes effective.
If it's silent, it becomes 30
Right, and if
days.
it says otherwise, then you would look at that.
Okay, because potentially they were already using the property at this time in 2021.
Well, part of the staff report, and I'll defer to staff to confirm, part of the staff report states that the previous property owner to this property graded the area to use it for a contractor's yard. Before that, I'm hearing from, the appellant that there was agriculture on the property, and I believe it was in a Williamson Act contract at some point in the past as well. I'll defer to staff to confirm.
But before,
Yeah, I understand that, but what I'm saying is, if now we are imposing a 2-acre limit that wasn't there when they were using the property after it got sold to the new owner, is there a time where they were already using the nursery, they had nursery operations going on, and then all of a sudden, the rules change, and all of a sudden, there's a 2-acre limit on the development?
if I can, through the chair, staff, be clear. The property was in violation, and a court order was issued for the property to be abated. Was that not the case? Did you not say that in your presentation? I want to be very clear. The property was in violation because of the base rock that was put on the acreage. We issued a notice of violation. The court ordered that the property be restored. The property was then purchased. If I'm wrong in that, would you please outline that situation, please?
You are correct. In September of 2020, the court issued an order directing the previous owner to abate the violations as it was laid out in the notice of violation. The property was sold to the current owner in March of 2021. And then in August of 2023, the current property owner entered into a compliance agreement agreeing to a timeline to abate the violation. And I think it's important to note that as there's a necessary precursor to any grading abatement application, the applicant has to submit a pre-screening where they generally sort of describe how they intend to either abate, legalize, or some combination of abatement and legalize the violation. And at that time, county staff did inform them that it was our view that base rock constituted development area and that we could not and would not be able to likely approve complete legalization of the base rock that was on the property.
Can I also offer some further clarification?
Sure.
So it is correct that the prior owners were responsible for the violations, but subsequent to that process of noticing the violation and trying to work with the previous owner to abate them, after the property was sold, the county entered into a compliance agreement with the current owners.
I understand that, yeah.
In the compliance agreement, the current property owners admitted and agreed that there was non-exempt grading without permits. I can find the exact language.
Did we get a copy in our packet of that agreement?
I'm not sure. So I will just say that they've waived their right to contest whether or not the unpermitted grading was exempt or not exempt. So we are very surprised to hear them now making this argument to you because it is expressly contrary to our compliance agreement. I will also say that the compliance agreement required the current property owners to obtain a grading permit. And the standards that apply are those that are in place at the time the permit is obtained. So the standards that we're looking at that would apply to this property are the ones as of the time that they receive the grading permit, at least as of the time that they entered into the compliance agreement in 2023. So even putting aside the Coyote Valley effective date, there are still standards that apply to them that they're required to meet, that the department's position is that they have not met them.
And if I may, through the chair, would it be helpful for the commission to get a copy of the compliance agreement that is signed?
I would definitely like that, yeah.
perhaps we can just recess for a few minutes and get you a copy of that compliance agreement so the commission can see what was issued to this current owner and what was signed.
Can that happen simultaneously while we continue the hearing? And then once we get it, then we'll take a break so that we can read it?
If I may, through the chair, it would be informational because the Planning Commission doesn't have authority over the compliance agreement. So this is informational for the commission.
As we learn from our truck depot in San Martin, yes, we understand that.
And staff can certainly track down and provide copies of that compliance agreement. So I'm very willing to go do that right now, although I do think a brief recess would be helpful.
Would an alternative that be helpful is if someone is able to pull up the relevant section of the compliance agreement showing the violation, or do you want copies made of the whole thing right now?
We can probably show the notice of violation, which was incorporated into the compliance agreement. That shows it was non-exempt grading.
Well, let's start with that, and we'll see if that answers the question. While we're doing that, what is the liability of the former owner at this point? Is there, are they, at what point is it criminal versus civilly responsible for their actions?
I can't speak to that. I think that's, yeah, a separate question.
I mean, once they sold it, they're completely off the hook from the notice of violation and
Well, what I can say is that the current owners entered into this compliance agreement
That I
where
understand.
they, the agreement is clear that they are not responsible for creating the violation, but they are responsible for abating it. And they, again, waive their right to contest the violations, which essentially means that they accepted that they are true and we agree that they are true. And one of the cited exemptions was for non-exempt, unpermitted grading.
right. But is there anyone else that can answer that question of what, if the former owner,
What,
once they sell it, they can just literally walk away, or is there any?
let me, just based on my knowledge that I happen to have that may get your question, I don't want to provide like legal opinion on the question you asked generally, but what I am aware of, and maybe Christina, you can confirm this with someone in our office who worked on the case. My understanding is that the county had litigation against the former owner for the multiple properties that included multiple violations and the fines assessed, and took that all the way to judgment for, or to settlement for a significant amount of money based on the administrative fines. And I don't believe that the current owners have been assessed administrative fines. Bart, I'm sure, could confirm that.
But what you're describing, though, is that the former owner did not walk away unscathed in this. They paid their penalty of what they did wrong through those, at least those fines, but ultimately, because the property, they didn't own that property anymore, they were no longer required to fix the problem, the violations in any way.
Right, if you buy a property that has recorded violations on it, you're
absolutely on notice
you're
and-
responsible for fixing the violations on the property that you're buying, yeah.
Right, okay.
So we have the compliance agreement. We're going to get it to Peggy so it can be displayed,
Okay.
Printed, correction,
for-
printed,
printed.
Yeah, clarification, are we printing or displaying?
printing.
Upon receipt, we will make copies in the back and distribute it to everyone on the dais.
So, do you want to take a break then? While we make copies?
I was going to have my colleague who is in the back do that so that I
Particularly
need
while
not
we're
leave
talking? All right.
my seat.
Efficient. Commissioner Belska, do you have questions for?
I do.
Yeah, okay.
Yeah,
Let's keep going
while we're waiting. So I guess even if the applicant acknowledged that the previous grading for the purpose of a parking lot was a violation, it is conceivable that they were not necessarily acknowledging that such grading for the purpose of a nursery was also illegal. So I don't necessarily think that they backed themselves into a corner by acknowledging that the previous use of the grading was a violation. That said, I have a separate question about the definition of development area, because it says that the development area is building, accessory structures, and associated improvements to those buildings and accessory structures. But if there are no buildings or accessory structures, then there are no improvements associated with those buildings or accessory structures. Therefore, there is no development.
Would staff like to respond to that?
Sorry, that wasn't phrased as a question, but that is how I'm interpreting the definition, right? If something is associated with something else, if that something else doesn't exist, you can't associate, the association doesn't exist either.
I hear your argument. I'll just say that the department vehemently disagrees. Development area can be development area regardless of exactly the use that it's put to. And crushed base rock is in many ways substantially similar to pavement or asphalt. And if 9 acres of the site was covered with pavement or asphalt, I think there'd be no question that that's development area. And I think, the reason that this is significant to the department is, the Coyote Valley, as was explained in the staff report, is a specially protected area. And if crushed compacted base rock was found to not be development area, then I think that would have a very significant impact on the Coyote Valley and the reasons that was protected locally and by the state in the first place.
Can I also follow up to that? 2 things. First, that base rock is not exempt under our ordinance, even if you were to conclude, which again is contrary to our ordinance, but if you were to conclude that the base rock is there for some type of agricultural use or connected to an agricultural use, base rock is not exempt. There is a grading permit exemption for agriculture. That's in Ordinance Code Section C12 407C. It doesn't address the importation of base rock. It addresses moving dirt around, routine leveling, plowing, disking, things of that sort. And that is because the exemption is intended to allow grading for things like ranch roads, dirt roads, that type of thing, among other things that are necessary for agriculture. Ranch roads are separately addressed in our ordinance code. They have to be made of gravel or a hard dirt surface. They have to be made of a certain width. So even ranch roads are not permitted to be paved with base rock. Just wanted to make that clear.
Commissioner Levy?
Yes, thank you, Mr. Chair. Hypothetical question, say that the commission does decide to grant the appeal and the project gets approved. Does that mean that the base rock has been approved in perpetuity. And so the nursery goes out of business in 5 years. And now we have 9 acres of base rock on prime agricultural land that was put in there initially as a violation illegally. So what happens? Does this if we go ahead with this, it's an approval of the base rock on the property?
Through the chair, Lisa McKyle. Typically, if you're approving the project as is, then that's allowed to remain. The commission has previously in the past conditioned a project that when a use was removed or left, that they restored it. The reality of that is slim. And in fact, we've actually had applicants come back and say, well, we've had it, we were going to introduce a new use to use that same grading that was there. And so staff would not advise the commission to do that, but again, it's at the pleasure of the commission how you condition a project.
Thank you, Deputy Director. And that's my concern somewhat. If they go out of business and the landscaping business isn't doing well locally, as the winery business is sort of hurting these days, what's going to happen? We're going to be left with 9 acres of base rock on prime agricultural land in a specifically protected area. And in essence, we'd potentially be approving an illegal activity with no definition or no ability to make sure that in the future that it's cleaned up. So although I'm really saddened that they're in this situation, I don't think that it's, and I am speaking sort of to where I'm going with this, that I don't think it's appropriate to move forward and approve something that was done illegally, that they knew the situation they were getting to, and the potential that we could be left with a mess if we do approve it. So, I think that and when I do look at the various items, the various findings that we have to make, I can understand how A and D, there's sort of questions. I think there's room for debate on those two. But on C, and I heard what the applicant said there, the counsel for the applicant, that said there is not an environmental issue here, that there is no landscape. Question for staff, is the primary agricultural soil that sits underneath the space rock, is that considered a natural resource? Or is that considered habitat or land, what's the specific words that were used here? Natural landscape, scenic, biologic, aquatic resources. Would that prime agricultural land underneath the bedrock satisfy one of those categories?
In the view of the department, yes.
And through the chair, this isn't an area of statewide importance, so it would be necessary for the department to review the project as proposed under the California Environmental Quality Act because it is a designated area of statewide importance. And prime ag land is a component of the review under CEQA.
Great, thank you.
Commissioner Belska?
Yeah, so the thing I'm struggling with here is that nurseries are allowed by right on this land. Nurseries reasonably require base rock. I've never visited a nursery that did not have base rock. Every single one I've ever been to has base rock. It absolutely seems fundamental. Like you cannot have a nursery in mud. So it's required by right. It needs base rock, but we don't allow base rock. Aren't we therefore saying we are violating their right to open a nursery?
If I could clarify for the commission, the position that the department is taking is not that no base rock is allowed, it's just that it does constitute development area and therefore there are limits. 2 acres of development area maximum with ag and 1 acre without.
And through the chair, I'll add one more. As I believe Christina Stella, County Counsel, clarified, the project is triggering grading. So there is a requirement to look at the
grading that was conducted on the property as well.
I'm sorry, I'm not following what your point was on that.
My point is that because there's an approval required, we're still required to look at the nursery with that base rock and the grading that occurred under the California Environmental Quality Act. So we're still required in the planning department to review the project. It's the use is allowed by right, but the development of getting that use on the property is discretionary through a grading permit.
Mr. Chair.
Go ahead.
Yeah, okay, so let me make sure I understand that clearly. What you're saying is that we may find out through the CEQA process that we have an unavoidable significant impact as a result of the grading, and then it would become discretionary, saying, since we have an unavoidable significant impact, the county has the right to deny the project.
So we've not performed the
That's a
CEQA
hypothetical,
analysis.
yes.
So I'll just be careful with responding to that, but because it is an area of statewide importance and there is a discretionary application, if the commission were so, if you guys moved to approve it, we would have to conduct CEQA. And there is a potential.
But CEQA, you don't deny, it just, you have to mitigate or, go through the process. Commissioner Cohen?
Oh, thank you. Just a quick question. If the appeal is denied, what is the next step for the applicant to allow their project to move forward?
They would either have to remove the base rock, or they could potentially file a new abatement application that complied with the development area limits of 2 acres.
And through the chair, there would have to be some sort of submittal that illustrated for the county to process them removing and restoring the property. We may be able to do that through an order to do that, but there's options available for them.
Could I just offer one? I don't know if this will be helpful in terms of the discussion of something being allowed by right versus then what standards apply. I think the house example from earlier may be helpful, right? You have a house may be permitted by right in an area, but there are standards that apply to how big can the house be, how do you construct the house, et cetera. The same thing is happening here with, you can have a nursery, but to spread base rock, you need a grading permit. And so once you are at the standard of, we need a grading permit, the question is what standards apply to the grading permit and how much grading you're allowed to do, or in this case, how much base rock you're allowed to put down under the applicable standards.
Is it possible for you just to highlight in the compliance agreement what might be important to us, and then we'll take a little recess and we'll look at it ourselves?
Sure.
Just walk us through what we're looking at.
Okay, so on page 3, terms of the agreement, acknowledgement of violations. The property owners, the current property owners, acknowledged that there was a violation of Ordinance Code C-12-406 for quote-unquote non-exempt grading without permits, including import and spreading of base rock materials across the property. There are other violations that the owners acknowledge related to grading, but I'll just highlight that one for purposes of our discussion. Section 2 of the terms walks through what they're required to do to remedy the violation. And that's why we're here, because they've applied for a grading abatement approval, which they need before they can move to the step of actually obtaining the grading permits. So section 3, issuance of permits, says that The property owners have represented that they will cure the violations.
Okay, so code section C12-406, non-exempt grading without permits, including import and spreading of base rock. So non-exempt, there's a lot of grading that happened. Are you saying that it was all non-exempt or there was some non-exempt? Because there's no amounts here, so
None of the grading was exempt from our grading requirements, grading permit requirements.
And through the chair, I can help further explain. In the code, it essentially gives you a cap. So you're allowed, for lack of a better term, by right, to do a certain quantity of grading. That would be non-exempt. Or if it's certain ranch roads are exempt from grading. So that's what non-exempt grading means. It didn't trigger the need for a permit. Once you trigger the need for the permit, oh, I'm sorry, what did I say wrong? I said something? Non-exempt. Yes, you're right. Non-exempt triggers the need for a permit. So once you trigger the need, you're no longer exempt.
I understand that.
There's not a quantity that this property has that falls under an exemption of grading.
It all doesn't, but you're saying you can do, what is 150 yards?
That's correct.
You can do, and whatever that spreads out to be from a base rock standpoint at 3 inches or 4 inches depth or whatever. So some of it could be considered allowable.
Well, by the terms of the compliance agreement, that's not up for debate. It's already been decided and approved by a court that all of the grading on the property is not exempt. That is the violation that was cited, and that is what the property owners agreed.
Okay. Just from my own knowledge, so if the other, let's say we didn't have a court order and one owner comes in and does 150 yards, and then a new owner comes in 4 or 5 years later, does 150 yards, or even the same owner over 10 years later decides, hey, I have another area that I want to get my tractor up and down or whatever, and puts more in. At what point is the 150 considered cumulative and you have to kind of combine it, and at what point can it be kind of separated out, just from my own knowledge? Does that make sense?
I think you're getting into questions for the grading official and code enforcement that are not really relevant to this application, and I don't know if we have the people here that can easily answer that. But
I think through your knowledge of how many use permits you guys have done, you've come across this, so I was just wondering in general terms, when is it considered a different event on grading permits?
Through the chair, we'll have to look a little closer. I'll see if I can look at that, and then I'll
Okay.
confer with county council.
Okay. Commissioner Belska?
Yeah, I wanted to circle back to a point that county council had made the example about a house by right, but still has to comply with certain requirements. But at some point, if the imposition of those requirements makes it such that building a house becomes impossible or infeasible, that could be considered a taking. And the same case could apply here, that a nursery by right, but imposing restrictions that then make a nursery infeasible could be considered a taking.
sorry, I'm going to have to correct you on that. A taking has to do when you've taken away basically any use of a property. So it's not a taking if somebody wants to have a nursery, but let's say, for example, we're in even a zone where that's not allowed. I don't know if that's hypothetically. It's not that I want a nursery and they're not letting me have a nursery, so that's a taking. A taking is when you've basically foreclosed any economically beneficial use of the property, which is not at issue here.
Commissioner Levy.
I was wondering if we want to ask the applicant back and close public hearing.
Well, I kind of just want to read through the
Okay.
the
Yeah,
thing,
okay.
just so in case we have questions, or they talk about it, then we kind of know. So let's go ahead and take 5 minutes to go through this. So we'll, whatever the appropriate term is, recess for 5 minutes. Okay, we'll call the meeting back to order, and we'll need to take roll call.
Commissioner Cohen? Commissioner Belska?
Present.
Commissioner Levy?
Here?
Commissioner Escobar?
Here.
Vice Chairperson O'Donohue?
Here.
Chairperson Rouser?
Present.
You have a quorum.
Okay, we're back. Let me just ask the staff on this agreement. Well, let me. Is there a way to have a new compliance agreement whereby the nursery could continue to function with an agreed about of existing base rock? So whether that's however many yards, probably less than what is currently on there, but is more than 2 acres, or is there, in the staff's opinion, there's no way, or even, is the staff's opinion you can't even get to, you can only get to 1 acre or 2 acres, or is there any way through this, a new compliance agreement that we could get to a place where this nursery can operate efficiently and possibly even agree to, if it does cease to be a nursery, remove the base rock at that time? Is that even a possibility?
I will just jump in because I know Christina hasn't at all worked on compliance agreements, so.
Oh, don't throw her under the bus.
Just as a general matter, I would say the county can't grant exemptions from the zoning ordinance and the county ordinance code and applicable standards in a compliance agreement, right? Like the standards that apply to a property that the Board of Supervisors have adopted that are codified in the ordinance code, even if the county thought it wanted to, which I don't, staff can speak to that, the county can't just say, the rules won't apply to you, and we're going to memorialize that in a compliance agreement.
Through the chair, I totally agree with council here. And so in this instance, the code says if you're over 150 cubic yards, and it does say independently and not annually or cumulatively, okay? In this case, the grading far exceeds that cubic yardage. It's in the thousands, and so they need to get a grading permit. So the compliance agreement's gonna say abate by remove or abate by apply for a permit to legalize or partially legalize. The project that is before the commission this evening is the applicant's request to, I believe, partially legalize some of the grading, perhaps even all of it. So
But under the grading permit, what is the staff's view of how much that they could do in the grading?
Sure.
Under a valid grading permit, under the code as it exists today?
So the department has to look at the proposal that's submitted to the county, and we have to analyze and assess that proposal. The proposal that was submitted, staff's not able to make those findings. Likely, if there was grading that was closer in alignment with the Coyote Valley standards, would be helpful, is a recommendation that I can provide. But we don't have a project before us to truly analyze that.
But you've stated both a 1 acre, or if it's related to agriculture, a 2 acre
That's right.
amount.
Right, that's good guidance to give. So when somebody comes to the counter and they ask us general questions, we would show them the code and we'd say, generally speaking, here's what you're allowed to do. Until you have an application that outlines exactly what a development project includes, you can't tell them it's okay, because there could be a stream that goes through it. There's a lot of different scenarios and every project's different. But generally speaking, if you meet this, that's good guidance for the applicant to fall in line with the code.
Okay. I'm trying to see how we could make it work, and ultimately, from what I can see, I can make the findings based on what I've heard, and I was hoping for possibly another avenue, but according to what I just heard, I don't see that as being possible, so. Commissioner Belska.
Can I get some clarification, please, on the compliance agreement? Page 3, the first, I guess the second sentence on page 3 says, "The subject property is currently being used for agricultural purposes." So doesn't that suggest it's being used for agricultural purposes?
Right at the second line on the third page, or first and second line.
The subject property is currently being used for agricultural purposes.
So I will just point out that, again, the violations, which are not in dispute, were for non-exempt grading without permits. We are looking at this agreement not to renegotiate it. This is not the forum in which to negotiate a compliance agreement. This is an operative agreement as it stands now. So taking a step back, the reason why we're looking at this is because the applicant now has come in and said that they should be allowed to keep the illegal base rock and grading because it's exempt from the county's permitting requirements. The purpose of showing you the notice of violations is to show that we have all agreed it is not exempt. And so we were just expressing our surprise at the argument that the applicant is now making before you today.
Okay, but if in the compliance agreement, all parties agreed that the subject property is currently being used for agricultural purposes, and development of agricultural uses are exempt from the above lot coverage standards, that would lead me to believe that the uses that the subject property is currently being used for are exempt from the above lot coverage standards.
So as Elizabeth explained, a compliance agreement cannot override our code. So the language in the compliance agreement may refer to it as an agricultural use because, as you all are acknowledging, there are some agricultural components to a nursery, but that doesn't change the fact that in our code, a nursery is classified as a commercial use and not an agricultural use. And again, the violations are what are pertinent to the discussion and the acknowledgement that the grading was not done for an agricultural or exempt use at the time that it was done in violation of the ordinance.
Okay, but I do find it somewhat problematic that the applicant agreed to this. They believed this is what they were signing and agreeing to, which led them to certain conclusions, right? They, in good faith, have been attempting to legalize the grading, and now it kind of sounds like the tables are being turned on them, and they're being told, no, this isn't agricultural use, right? Like all the following two paragraphs also seem to imply, let's see, what's the other one? That after the expiration of the Williamson contract, the property owner's desire to make use of the existing grading on the subject property to construct a nursery. So all of this was outlined in the compliance agreement, and this is what the applicants agreed to.
Through the chair, I just want to clarify that the department is not saying that a nursery use cannot be established on the property. The department is saying that the grading that has been conducted requires review and approval. If the commission so moves to approve this, we would look at it under the California Environmental Quality Act as the next step, and it would come back. We would review it, actually, I believe, at the staff level for that. No, I'm not sure. It would come back to the commission, still on the appeal.
Sorry, let me just, so if we approve this, we're not approving that all of a sudden, poof, right, it's all done. If we approve this, you have to go through CEQA, then, assuming that goes forward, then they apply for a grading permit, then you review that, right? Those are the next steps.
Yeah, so I can try to clarify the process. In the recommended actions, there's either to deny the appeal and uphold the department's decision, or, I don't have the exact language in front of me, but basically you would declare your intent to grant the appeal. Then it would go to do CEQA and to draft conditions of approval and come back to the Planning Commission for consideration based on the declared intent today. And there would be another hearing where you would address kind of the additional CEQA analysis and the conditions of approval. And I don't know if it would be helpful for staff to explain the tiered process for grading abatement, and basically what's decided for grading abatement, and then how the grading permit kind of flows from that, and what the different considerations are at grading approval and grading permit under the approval.
Certainly happy to try to explain that process a little bit. Grading approval is really, it's a planning process whereby we look at a conceptual grading plan to try to determine if it's approvable based on the findings that were discussed, that have been discussed at length here this evening. Once that grading approval is granted and any applicable conditions of approval have been met, then the applicant can submit a grading permit, which shows sort of exactly how engineering, the grading is going to work from an engineering standpoint. So again, the grading approval is really a sort of conceptual approval based on the ability to make the necessary findings, and then the grading permit is exactly from an engineering standpoint that grading is going to occur. And at that point, the approval is ministerial. In other words, if all the required requirements for grading a permit, analogous, say, to building code requirements, are met, then the grading permit is issued.
Commissioner Escobar and then Commissioner Levy.
Okay.
And I do plan on giving them their rebuttal time, so.
Clarification. This agreement is a legal binding document that's been notarized, that you would hold the applicant to task for and say, you need to comply with this. But then we start talking about saying, well, we don't exactly agree that we can hold that subject property is currently being used for agricultural purposes because we can't take this sentence to be a binding sentence, but the whole document is binding on the applicant. That's my first point of clarification, really not clarification, but confusion, because either the whole document is valid and binding, or it isn't. We can't pick and choose out of it, which is what it sounds like to me. But secondary to that, when I'm looking at staff's report, packet page 8, under project setting, it tells me that the Williamson Act was terminated in January 2023. Owner decided not to renew, so they're no longer under Williamson Act. I go back to this document again, the compliance agreement, page 3, second and third paragraph that references Williamson Act contract, but in the very second one it says, after the expiration of the Williamson Act contract, property owners desire to make use of the existing grading of the subject property to construct a nursery, blah, blah, blah. It does not talk about any version of you have to correct your violation before you use existing grading. So things are starting to really conflict here, and I'm confused as to, am I supposed to just throw out pieces of this document to serve my argument, or can I use them to serve my argument? Or is it the whole thing? Which is it?
So-
Because it's doing this.
Yeah.
And I'm not okay with this, which makes me say I want to send this back to staff and go and do better in working on this issue with them, so we don't put somebody out of a particular business because we're doing this.
Right. So you don't need this document in front of you, which is why it wasn't part of the packet, to have like
Unfortunately, it is though now.
Right, but and I'll get to what you were saying.
Okay.
But I just want to clarify that, like, what's before you is the grading abatement approval and what they've applied for and are proposing, and does that meet the county ordinance code and zoning ordinance standards? This doesn't change the county zoning ordinance standards, the county ordinance code standards.
I do understand
Yes.
that, but if their attorney brought this argument forward as a reason to justify or to explain, you would listen to it, correct? Is it that I'm bringing it forward, or they should be bringing it forward?
I haven't heard
I'm
Bart
just
make a-
curious, like, does it even matter if anybody brings it forward? Because we're here now.
Right.
And I see this, and I can't look away from this in asking that question.
Yeah, so, and if it's helpful, neither of us worked with Bart on this compliance agreement, so I'm just going to try to read what it says and what I think it doesn't say, and of course, Bart can speak to his experience with the compliance agreement, and I wasn't part of negotiating it, and I'm just trying to help provide clarification to the Planning Commission and not argue anything one way or the other. Like I said, from a legal perspective, right, we can't change the zoning ordinance or county ordinance code standards. What I see in here is a reference to agricultural purposes, but it doesn't say, for example, the parties agree that a nursery is an agricultural use under the zoning ordinance. Like, maybe in everyday language, people want to refer to it as agricultural. I don't know, I wasn't part of it, but it doesn't say this counts as an agricultural use under the zoning ordinance of the county, which the county could not have agreed to. Then it says the property owner's desire to make use of the existing grading of the subject property to construct a nursery. So we understand that that's their desire. It's not the county agreeing that yes, everything you want or desire can be legalized. Instead, it's the county agreeing to a process for how the applicant will apply for a grading abatement approval, and then the standard, that what they're proposing for their desired nursery use will be analyzed under the applicable standards through that grading abatement approval application.
So then shouldn't we have addressed that before we got this far? That this is their desire to use existing grading, and we know they're not compliant? Well, I would say previous owner and current, in that they didn't follow through completely. So I'm just a little.
I'm not sure I understand your question.
I guess I'm still in the place of, why is something in here if I'm not supposed to pay attention to it? And they're held to it, and we're held to it, so to speak, right? Everybody who signed this is held to this document that now has language in it that I'm basically being told, well, that part doesn't really matter because, well, it just doesn't really matter. And that starts to confuse me, because then why is it here? And I know you didn't write it, you weren't a part of that, so it is hard to know intent as somebody not being the author. I totally get that. But as somebody who now has a document in front of them, I can't unsee what I saw. And I, again, am still in the place of this that makes me say, I can't tell you no, because there's too much of this happening here.
And I'm sure Bart could speak to this too, because I know he works on plenty of compliance agreements for the county. But basically, it's not uncommon to say, this is how the property owner hopes to abate violations that they agree exist. So they agreed a violation exists. They have to legalize the base rock that was put down without a permit. It was illegally done. It was a violation. And then there may be different paths for ways that they can legalize that. The county does not agree up front, yes, you can do this, or no, you can't do this. They say these are the options you can pursue for trying to get to what you want. And here, for trying to get to what they want, is submitting a grading abatement approval application, and then the county will evaluate the specifics of their application and how much they're hoping to keep from the base rock or not. And if it's legalizable and they get the approval and the grading permit, then they can keep what was legalized. And if there are parts that wouldn't meet with the county standards, then they've agreed they would have to remove it to abate the violation.
Commissioner Levy?
All right, thank you, Mr. Chair. Yes, this is a very confusing document for non-lawyers, and so maybe Mark understands, maybe our chair understands if the rest of us are struggling a little bit. But I do see in here, under pretty much all the different line items, where it says permissible under zoning ordinance according to applicable permitting requirements, and then the next one, it says in a manner compliant with zoning ordinance and zoning code and zoning ordinance without limitations, and it goes on in
What page are you on?
Oh, this is just a follow-up to what Commissioner Escobar was saying. It's on page 3.
Okay.
Where it does initially say, this is what's going to be allowed, but only if it follows existing rules. And then it says only if it follows existing rules over and over again throughout the course of the document. Here on page 2, on page 3, on page 4, under A, B, and C. And so, yes, I understand it's very confusing, but it is saying, these are allowed if you follow all the rules and regulations. So that brings us back to the findings and whether we can make those findings or not, and whether we do consider it to be within the rules and regulations. As council says, this document is not the general plan and the zoning rules and everything else. This is a compliance agreement where it does have that out on every line that says when in compliance with our existing rules. So I think we're all the way back. Again, I agree with council, put this aside and come back. Does this follow the rules or not? And does this follow the basic concept of what agricultural zoning allows and what we should be allowing on prime agricultural land? Again, I think this is wonderful stuff, and I'm confused as heck by reading it, but I tend to agree it's a little bit of a distraction because it's not something that we can clearly understand. And the way I look at it is it says both. It says, yes, this is what they should be allowed, but only if they follow the rules. And then it applies all the steps on how they can apply, how they can get to applying the rules.
Commissioner Belska, did you have your light on or no? Okay. So I'd like to make my own comment on this and then allow the applicant to have a rebuttal and if we have any questions. Commissioner Escobar, I completely agree with you that this, whether or not it was intended, the department put a stamp on this saying it's being used for agricultural purposes. Had they known what this was going to come, they probably would have then put in, the lawyers would have got involved and said, but it does not qualify under section, it does not nullify the commercial whatever, but this is there and it speaks to common sense. And when I read the letter from the attorney on this thing, there is conflicting stuff in the code, and so yes, one says this, one says that. Well, you start adding all the conflicting stuff, and then you have an agreement where they basically agreed that this thing is agricultural. When you hear the statistics of all the ag revenue, they put nurseries up there. To me, I can find the findings just looking at everything together. And in my mind, there's still CEQA, so there'll still be, an environmental sanity put on it. And so I'm leaning towards that, but ultimately I'd like to hear more from the applicant on, from everything you've heard, you have up to 10 minutes to enlighten us. Straighten us out.
Okay, thank you very much. So let me start by asking staff to please pull up the definition of agriculture from the same chapter 2.10 that they showed the definition of nursery. So if you can just go ahead and pull that up. What you'll see is that
Through the chair, is that acceptable? Yes. Okay.
Thank you.
Yes, please.
Thank you. what you're going to see is that the description of agriculture describes what Coyote Valley Nursery and every other nursery does. It's growing crops and horticulture. Agriculture even includes, as we'll see eventually, crops grown within greenhouses. And all of these uses, there we go. So I want to start by pointing out that the word in parentheses is agricultural, and raising of, I'm just going to sort of hit the highlights that apply here, raising of crops, including horticulture, crops grown within greenhouses, and that's it, right? It's perplexing to me that we're actually debating whether or not commercial nurseries are agricultural. As I mentioned earlier, when you read laws, like the county's laws, you have to harmonize them. And when they conflict, you have to read them together so that they both make sense and neither one makes no sense. And here, wholesale nurseries are commercial agricultural uses. And that's why I think that that's widely recognized around the world, not just, this county might be the only place that is disputing it, at least some members of county staff. It's, as has been pointed out, it's stated in the compliance agreement as an agreement, and honestly, as someone who has, I've negotiated, I think, to completion at least 12 of those compliance agreements, and I've got a half dozen more. It startles me to hear staff say there might be parts of compliance agreement that's signed by the county and recorded that you can't hold the county to. I want to treat that as just a misstatement because it was agreed upon. I also want to point out, and the chair alluded to this, this is the last page of my letter. This is a table from the draft EIR that the county has prepared for its ordinance revision, its rural ordinance revision. And this chapter is called Agriculture and Forestry Resources. And the number one crop from 2023 at 127 million is nursery crops. Nursery crops. So the county treats these as an agricultural use, and that's the point, is that it's not development area where it's, as Commissioner Belska pointed out, not associated with any building or structure, and rather associated with the agricultural use. And I will tell you that this issue did not come up in developing the Coyote Valley rules. There was never a discussion about, well, what about nurseries that use base rock to help them flourish, right? And you know, are we going to include that in development area? And that's why it's silent. Those rules are silent. They do not talk about base rock. All right. Now let's talk about the compliance agreement for a minute. I did help negotiate this, and a couple of really important items. First of all, there may have been a statement earlier that we're required to remove the base rock. So what we're required to do is abate the violation. Mario bought a property with a violation. You have to abate the violation, and you do that in one of two ways. You legalize or you remove. You put it back to the condition before the violation existed. It's very clear when you read the compliance agreement that what is designed here with a schedule is an opportunity to legalize, and if that fails, then you'd have to remove. And the opportunity to legalize is to apply for a grading abatement approval, which, if granted, allows us to obtain or to apply for a grading permit. And and this is where I think you spent a half hour discussing in various questions an issue that's a non-issue. There is no material that we submitted, and there was no comment you have received from us tonight that said or even implied that we believe we are exempt from the requirement to go through this process. It's just not true. In fact, you heard the opposite from us. You heard both Gloria and I say, to legalize this, we need a grading permit, which means we first need a grading abatement approval. So there is no discussion here relevant to your decision about whether or not we're exempt. We're not. If you want to bring all this base rock to a property and do it the right way, you get a permit first. You get a grading permit first, right? You know, this property owner came to the property where that had already been done illegally. So, but the right way to do it is you get a grading abatement permit. If you don't get a grading abatement permit first, the county rules require you take an extra step and get a grading abatement approval first. But absent a violation, you have to get a grading permit. But that's it. That's the only permit that is needed for this, and we're trying to get to it through this grading abatement approval. So, but there is no contention here that we're exempt. And that's why we agreed in the compliance agreement that we're not exempt. We need to get these approvals in order to make the use. Let's see, the next item is in response to Commissioner Levy's question about, well, what happens if the use ends and the rocks are just left? And that's a good question. And the answer is found in many, many county approvals. You condition approval on the removal of the base rock, and where you have concerns that that condition might not be administered by somebody departing, then you require an enforcing mechanism. So one example of that is you record against this condition against the property that requires the base rock to be removed before the property can be transferred. Another thing that I've done a lot of work with your quarries and some other construction contracts, you require a bond. Right? Very simple, right? And so that is how you assure yourself that the condition you impose today will be complied with tomorrow. And again, those are easy answers. And then on CEQA, first of all, I don't believe that there was any reference to having to go through CEQA. In the event you decide to uphold the appeal, I question whether CEQA will be applicable. Remember, CEQA is analyzing at changes in the environment, right? This is property that its existing condition is base rock. And so we're not proposing to change the environment. Well, actually, it would be more of a change to remove that base rock, but that's a kind of a discussion potentially down the road after you hopefully agree to indicate your intention to uphold the appeal. The other thing is, in that CEQA process, if this weren't exempt, you'd still be looking at mitigations. And one of the mitigations could well be the condition of approval that I've just described, right? Require removal at the end of the period, secured by either a recorded document or a bond. So I don't think that CEQA is really an impediment here. I certainly don't believe it's going to result in a need for a statement of overriding considerations, whatever it does require. So I tried to address all of the points that I heard that really needed some elaboration. I'm happy to answer any questions you might have.
Thank you for that. Any commissioners have any further questions? Okay, we'll close the public hearing and open it up for discussion. Vice Chair O'Donoghue.
Yeah, it was a lot of good information that we heard back and forth. It's clear to me that this base rock is needed to operate the nursery. There's conflicting information in the COAs. The county has said the subject property is currently being used for agricultural purposes. So I'd like to make a motion to declare intent to grant the appeal and rescind the decision of the Department of Planning and Development to deny the grading abatement approval and return to the Planning Commission for final action.
I'll second that motion.
Okay, we have a motion from Vice Chair O'Donoghue to declare intent to grant the appeal and rescind the decision of the Department of Planning and Development to deny the grading abatement approval and return to the Planning Commission for final action. And a second by Commissioner Escobar. Any discussion? Commissioner Levy, it looked dark from my angle, but go for it.
All right. The counsel for the applicant mentioned the potential bonding or having some type of lien against the property or something of that nature. If, to require the base rock to be removed at some point in the future, either with the sale of the property or say 10 years out or something of that nature. What does staff think about the proposal such as that?
Through the chair, Deputy Director Lisa McCall, I believe we less often do the bonding. It'd probably be better to record it against the property so that any future purchaser was fully aware of the requirement. That's based on my personal opinion. I think it's at the pleasure of the commission as long as it's legally allowed.
Okay.
So that would be potential lien against the property for the next owner, or, I mean, how does that work?
Through the chair, it's not, I don't believe it's a lien, it's more of a notice, but I have to defer to council on what that could look like. But we can record it against, you can record the conditions on the property, and so that's essentially a notification. But again, I'm not an attorney, so I can't speak to that legally.
I find this an extremely challenging item on our agenda here, in that, it's definitely, I think the applicant has done this in good faith. They're following the rules as they apply, and potentially approving or denying the appeal could potentially in serious hardship for the applicant. But the goal of the Planning Commission is to follow the rules of the county to a T, and not really take into consideration much as far as the individual property owner, because this is in perpetuity what we're doing. In essence, potentially approving an illegal use, illegal grading, and having that illegal grading be approved in perpetuity on what is considered prime agriculture in the county, and a special area prime agriculture as well. And so, like I said, this is very challenging, because I do not like denying this kind of, denying an application like that, because I understand the hardship it's going to take, but I understand also my job as a planning commissioner is to uphold the rules, and I can't make those findings right now, and I don't think that the nature of the general plan and the nature of the plan, the agricultural plan for the Coyote Valley climate resistant area is meant to be paved. And I don't think that's something we want to approve for into perpetuity. So as much as I understand this to be a hardship on the applicant, and I understand that they have done their due diligence here, I think as a commissioner I need to abide by what I think is what the general plan is trying to do here. And the general plan is trying to preserve agricultural land within the Coyote Valley. And so, I will not be supporting the motion.
All right, thank you. Commissioner Belska?
So I agree that we need to follow what's in the ordinance, but when the ordinance is ambiguous, we then have to interpret what we believe the ordinance says. And I fully agree that there is no reason why a nursery can't be classified as both agriculture and commercial. Those two things are not mutually exclusive activities. And that is my interpretation of the ordinance. So I do believe we're following the rules, and I would support the motion.
Vice Chair O'Donoghue, you have your mic on, are you?
Oh, sorry, I was just waiting for the vote.
Okay. Could we get a roll call vote on that?
Commissioner Cohen?
No.
Commissioner Belska?
Yes.
Commissioner Levy?
No.
Commissioner Escobar?
Yes.
Commissioner Vice Chairperson O'Donoghue?
Yes.
Chairperson Rouser?
I approve.
Motion carries with 4.
Is there any statement that needs to be read on this one, or no, we're good to go?
No, because it has to come back. So
Right.
after it comes back. Thanks, though.
Number 6, receive the report from the chairperson. Since it's nowhere near 10 o'clock, I'd like to go through a couple of items, if I can, if you will indulge me a little bit. I have at least 3 items. This week, I participated in the Cordoval Youth Golf Foundation, of which I am a member because I'm from Seat 1 in the South District. And as part of their use permit, they were required to have a public function. And so they donate over $100,000 every year to, in this case, we apportioned it out to 30 different schools that supported 600 student athletes in golf. And then there was 2 other golf foundations, the First Tee Silicon Valley and San Jose Muni Junior Golf Organization. And those 2 have a slightly different model, but they benefit 2,400 youth with respect to golf. So they give like clinics and different things like that. I also attended the 94th annual conference of the California County Planning Commissioners Association. That was in Tulare County. So for 94 years, they've been having a conference. So even through whatever epidemics we've had. And it was interesting, some of on the history of it, that planning commissions were actually started in California, and in 1929 is when they officially started that organization. There was about 6 counties that actually had planning commissions at that time. So I did not know that planning commission was California unique. Now it's of course everywhere. But the California County Planning Commissioners Association, it's not an advocacy group, and it does not espouse particular business or political motives. They're just an association of and for planning commissioners. Their aim is to inform and educate our fellow commissioners on trends and best practices in the planning environment, and to foster a free exchange of ideas that will ultimately assist our arrival to optimal planning decisions. And what I learned from it is not many counties attend. I don't know if there's like 58 counties or something like that. But a lot of these are rural and or have a rural-urban interface. And so I was able to get a lot of good information from that. And during the conference, I'll just go through a couple of the things that we did. They have a Tulare Business Innovation Zone. So they're trying to help small businesses. So they took a vacant former courthouse building, and now they have like computer labs. You can have office spaces, different things like that. We went through the Rexford Solar Project drive-through, and that was 3,800 acres, which they have, they're putting in solar. And the way they do it is they're literally just putting metal posts into the ground that can just be taken out. So it is ag land, but it can be purposed right back to ag land. Right now it's delivering 300 megawatts of solar power, but they can go up to 1,200 megawatts over different phases. We visited Seton Pistachios, and that's, they do over 250 million pounds annually, including Costco. It didn't make it home. I ate them all. They were so good. The company is recognized for sustainable farming practices, large-scale solar energy use, and innovative recycling of byproducts, while also expanding into organic production and global distribution. So they're the number 2 biggest pistachio processor, and they do Germany, they do a whole bunch of stuff. Then there was another very interesting, it's called Salt and Light, and that's a nonprofit dedicating to ending homelessness through community dignity and purpose. And they created a neighborhood village, which is Tulare County's first master planned permanent supportive housing community, offers stable homes with wraparound services, job training, and holistic care. And we saw the houses and stuff, and they were just, I mean, they're very small, but the people that were in there, they came from very challenging backgrounds and stories, and they are excited to be able to have a place to go. So I thought that was innovative. And right next door to that, they have what they call self-help housing, which is basically, that's another nonprofit, and they've been around longer than Habitat for Humanity, which was actually Habitat's a similar kind of offering. So we saw them, this was I think on a Saturday, and so what they do is they go and they build 10 homes at a time, and the people who want to live in those have to contribute, as they call it, sweat equity. And so there are 1, 2, and 3 bedroom units, and so they build 10 at a time, and you can't move into your house until all 10 are built. So you have to keep helping out, and you can get, in some cases, you can get a relative or something, that there's a requirement of how much you have to participate in this. And it was just phenomenal just to see they were pouring the foundations and just families out there working on it. And then the last one I'll talk about is Calgren Renewable Fuels. So Tulare County, I didn't know much about it, but they're known for having more cows than people. And so Calgren Renewable produces over 55 million gallons of low-carbon ethanol annually, while capturing methane from nearby dairies to generate renewable natural gas, electricity, and valuable co-products like animal feed and corn oil. The facility powers its own operations, supplies excess energy to the grid, and is advancing carbon capture, making it a leading model of sustainable circular bioenergy in California. They literally had 55 miles of piping from the dairies to get the manure basically gets converted into sludge, and it goes through these pipes, and then they convert it, and they literally had no byproduct, everything was reused in some way. And they also bring corn in and stuff to make ethanol, and all the byproducts of even that corn and everything get reused. So it was fascinating, and I want to say thank you to the county for allowing me to do this. And even though I love the APA in that conference, this also, I just want to say it provides something different, and I want to just encourage as many people as can to take advantage of this, just because there's just a lot of good stuff, and because of the rural component, it was very nice. The last report I had is today I went before Hewlett and reported on our progress. Since I also reported in May of what we did last year, so this was a very small window. And so I'll just say I made that report on your behalf, and you all looked very good on that. And my report lasted possibly all of 15 seconds. So with that, any reports from commissioners? Commissioner Cohen, you don't have a report. Okay. Receive report from County Council, number 8.
I don't have a formal something to report, but I do just want to recognize that this is Peggy's last meeting as our clerk, and I want to say it's truly been a pleasure working with you. You're a rock star. We're going to miss you so much. And I can't express enough the gratitude for all of your hard work and your public service.
It has been my distinct pleasure and privilege to work with you all.
Can we all second that motion?
We will have our opportunity under announcements and correspondence.
I
Thank
say
you.
we do it now. We're in the vein. Let's keep going.
Okay. Let's just get through this, and then we have a whole roast for her. We're gonna Okay, is that it for county council? Okay, number 9, receive report from planning commission secretary.
Lisa McKyle, Deputy Director. I'm going to try and combine 9 and 10
Okay.
from the department as well from the Deputy Director and the Planning Services. I do have to admit that I did lie to Peggy earlier this evening when she tried to make sure I wouldn't say anything. So I did lie, so I'm sorry for that. But I do want to make sure that I recognize you. From my personal experience when I came on to be the planning secretary, you were, whether you know it or not, a mentor to me because you showed me the way on how to process everything through the agenda prep and everything. So I want to thank you. You were, you sat on our floor for many years, and everybody appreciated every moment that you were there. You went through painstaking references through the past logs that we had and put everything in order for us, and you kept us in order. And so you're such a pleasure. We're going to miss you. And I'm going to just pause for a second before I hand some things over, because I also know that Principal Planner Rob Salisbury would like to say some stuff too.
Yeah, thank you, Lisa. Yeah, Peggy, it's just been a pleasure working with you. It's rare that somebody is such a consummate professional and also at the same time such a lovely person. And you're going to be sorely missed, but I'm also extremely happy for you that you're starting your next chapter. So I hope to join you there soon.
Not this week, but.
Not this week. Yeah, it's just been a delight working with you, and you will be sorely missed.
Are you done then with the deputy director? Okay. Our esteemed director.
So Peggy, I just want to say to you, there's a saying that excellence is to do a common thing in an uncommon way. And you have just been stellar working with us. You've given us amazing grace when we've misstepped. And just the integrity by which you operate, the joy by which you do your job, but the grace that you give a young staff, the kindness by which you operate has been lost in our society. We're not seeing that kindness. And you are just a wonderful, delightful person. And it is a pleasure, it has been a pleasure for me to work with you. Words are very important for me, and colors are very important. Yellow is the color of friendship, and we will not forget you, your kindness, your friendship to our department, to the staff. You're just an amazing woman, and thank you. Thank you for sharing your skills with us. Thank you for sharing all this time with us when we were tardy on our staff reports, when we had incorrect notices. You've just been an absolute delight, and thank you. Thank you for being you.
Thank you, and I feel compelled to point out that planning is by no means the only department that is sometimes tardy on lunch class.
This is my last planning commission, and so I will not be back to planning commission, but I just want to say thank you.
I am sorry to hear that. Okay, announcements. Peggy is going off to do other things, and we have a gift basket for you and some flowers from a South County establishment called the Nest Box. You want to?
There was no way, Peggy. Nice try.
So we were told you do not want a fuss in any way and do not want any attention, and so that, of course, became a challenge to us to make your life miserable. So thank you so much, and does anyone have any, we have some other comments we'd like to make, and I know you want to get done with this as soon as possible, but. Commissioner Escobar.
Peggy, you had big shoes to fill, I'm just going to say, and you far exceeded them. And I don't know how many remember Michelle Napierre, which Rouser would. Michelle was amazing, and I knew her since 1999 when I came here and worked for then Supervisor Pete McHugh for District 3. And then when I came back as a commissioner, she staffed Planning Commission and was amazing, and then unfortunately passed away suddenly. And here came Peggy. Hard. Sorry. I didn't think I could love anybody as much as I love Michelle. And you just stepped in, took us by the hand, because we were a little lost because we had such a strong person leading us, and was amazing. And you far exceeded Michelle Napierre. And no disrespect to her, because unfortunately she's not here. But you've been amazing, and you deserve every happiness in your retirement.
Commissioner Levy?
Oh, Peggy, you're amazing. I've been on a lot of commissions and committees and so forth, and I think we've never had a clerk that just makes things flow as smoothly as you do. You know, just the way you answer all the emails, and always in such a positive and often humorous manner, and it's just, you know, you're just great, and you've done a wonderful job. But I remember was it 2 years ago you said you were going to leave us, and here you are. So, so it's like you're going to take a couple months off, and then you're going to come back, and we're not going to lose you, because we really don't want to lose you.
I'm definitely retiring. My last day on the books is December 26th, although I will absolutely be in touch with my colleagues who are my friends, and I have offered to, like, if they get really again in a bind with the Planning Commission, that I would help out. So.
Well, you know, there's always extra help in 6 months.
I'm not planning 6 months out yet.
Commissioner Belska.
Yes, thank you. So I'm newer to the commission. You know, I haven't known you for nearly as long as all of these other folks. But even in the short time that I have been a commissioner, you have been absolutely invaluable, especially as, you know, a newbie coming on, not knowing a lot of things, just, you know, being often confused. You know, I've reached out to you a lot, and you've always been so very helpful and gracious and wonderful. And yeah, I will be very sad to see you go. But congratulations.
Thank you. I'm very excited about it.
Vice Chair O'Donoghue, do you?
Yeah. You know, when I first joined the commission back in 2021, Peggy was the very first face that I saw, and it was the most gracious, most warm welcome that from somebody completely outside of the organization, you know, could have possibly received. And it became very obvious very quickly that Peggy has been the adhesive or the glue that holds a lot of this together, and you just kill it every single day, and your positivity, your smile is just so warm, and I I would have really struggled more than I did as chair of the commission without Peggy's help. She really helped me out and made it look like I knew what I was talking about and how to run a meeting. And I'm gonna really miss your all your warmth, your smile sitting across from us over there. Yeah, I don't know how do we replace that? I don't know how we do that, but I wish you all the best in your retirement, and thank you so much for everything, Peggy.
And I would also just like to say, you're efficient and you're professional, but you're just a great person, and that's what, in my mind, puts you up into that stratosphere up there. So you're on a pedestal for me too. So again, oh, another light. Commissioner Cohen.
I just wanted to say, as one of the newer members, how grateful I am for you to guide all of us with such professionalism and kindness. But I just really hope that you enjoy your retirement and have as much fun as possible and take a break and appreciate the infrastructure that really allows all of us to, again, show up as prepared professionals. And I just really appreciate your respect and your thoughtfulness. So thank you.
Okay, I'll keep moving, let you off the hook a little bit. There are currently no vacancies on the commission for internet access to vacancy and applications. Actually, there is a open seat on District 2, I believe, so look to the website for that, www.sccgov.org/vacancies. The County of Santa Clara provides reimbursement to appointed commissioners for family care expenses incurred during the time spent performing their official county duties. Contact the clerk if you want to know more. We did receive correspondence, including from our friends at Peacock Court. We took care of the consent calendar. Number 17, adjourn. The next regular meeting is scheduled for Thursday, December 18th, 2025 at 6 p.m. in the Board of Supervisors Chambers, 70 West Heading Street, San Jose. And it looks like we will have, at this point, items on that agenda. So with that, I will adjourn.
Could I just say, for next month's agenda, if you saw the correspondence, the Peacock Court item will likely be on the agenda. Just for the commissioners who haven't been here for the prior hearings, I'll send out an email with links to the prior hearings, but it's recommended that you watch the videos from the prior hearings so you understand what has happened thus far.